Arbitration is part of what's called alternative dispute resolution. What that means is it's a way to get you out of the court system. An arbitrator is essentially a judge. It's somebody who will make a decision for you, but in a private setting. So for instance, in your conference room, all the parties show up with their attorneys, and you have a mini trial, and you have an arbitrator who takes the place of a judge. And the arbitrator's decisions are binding. You can control to a certain extent how binding they are, whether they can be appealed, whether they can't be appealed, whether the arbitrator is working on only limited issues, all different issues. But what it offers you is certainty as to when you're going to have your trial. You're not going to be sitting around a courthouse waiting for a judge to be ready for you. You can control the schedule for everybody. You're going to show up on Monday and Tuesday and Wednesday, try to get everything done. You can control a lot of the aspects of a trial that you cannot control in a court. The judge has to do certain things in the court. The judge is required to come to decision certain ways. With an arbitrator, you can set the rules by consent. The arbitrator himself or herself is somebody who should be very qualified in the area of law that you're trying to work with. So for instance, I've served as an arbitrator in quite a few matrimonial cases. Retired judges serve as arbitrators. There's a cost to it that you don't have. You don't pay a judge to go to court, but the cost is more than compensated by being able to limit the amount of time that you're spending to finish your matter. And by the overall quickness is a very good thing. And the overall control of costs, including, as I referenced, there's court costs that you can't avoid, the shortcuts that you can take with an arbitrator. So it's becoming a very popular way of litigating matrimonial cases to a conclusion. It's popular with, obviously, the litigants because they save time, they save money. It's popular with the attorneys because they're not sitting around a courthouse. So when an attorney, for instance, like myself, has to bill a client, you're not being billed for wasted time. It's a very viable alternative. The downfall is that you are asking somebody outside the court system to make a decision. And some people aren't comfortable with that, especially when it comes to custody matters. Sometimes you really want a judge in a courthouse in that setting to make a decision about custody. But again, you can limit it to financial matters. You can limit it to however you want, but it's becoming a very popular method to use. You can choose an arbitrator who is not even well versed in your area of law. It could be a non-lawyer. People have accountants sometimes to do arbitration when they're trying to resolve the value of a business or other financial aspects. You could have a mental health professional actually arbitrate an issue that has to do with custody of the children. But what you really want is somebody who knows the law well, who knows the rules of evidence well, who knows the rules of court well, and who has handled these things before, whether they're a retired judge, whether they're an attorney who's been through many trials, been through these wars many times. The more experience you have, the quicker a decision it's going to be, and the more reliable and accurate the decision it's going to be. As surprising as it may be, an arbitrator can actually have more power than a judge. A judge always faces the possibility that the decision will be appealed to the higher courts. With an arbitrator, both parties can agree that the decision is non-appealable. It's final, it's binding. It might be appealable under very limited circumstances, but again, you can set those limits. So for instance, when I've acted as an arbitrator, sometimes I've had more power and had the ability to do more for the clients than a judge could actually do. That could be scary to litigants because you're asking a person, again, you don't really know that person well if you're a litigant. The lawyers know you well, but the litigant doesn't know you well. So you're giving somebody a lot of power, and that can be scary for people, which is one of the reasons people still choose to have their trials in court sometimes, just because of the unknown of a person who's not wearing a black robe making these decisions over your life. What types of cases should not go to arbitration? Really, any case can go to arbitration. I mean, again, it could be a limited type of issue. Sometimes when I'm faced with the choice of going to arbitration, as an attorney, I might be thinking about what leverage my client might have in a court. So in other words, if my client's spouse has deliberately withheld money or not reported income or done something illegal, do I want to go to court to put a little extra pressure on the other person because a judge might have to report them to the IRS or to some other entity? So there could be strategic reasons to not want to go to arbitration. Sometimes it's just the client's comfort level, though. People don't like relinquishing decisions to people who look like them. They're sitting in a conference room like them, and they don't think of them as the judge in the case, even if they're a retired judge. So strategically, there could be reasons, and there could just be a comfort level. Then there's also the cost. Typically, arbitrators who are very experienced attorneys or retired judges are in the higher cost bracket. So you know that there's going to be that additional cost.